Things are heating up, guys, as the New York Times has taken a daring legal stance against two of the biggest names in the tech industry, Microsoft and OpenAI. The media titan promises an in-depth drama that may change the course of journalism and artificial intelligence. Yes, I have been talking about this on my videos, how AI is killing the writing and designing work. But this time, it's not me. It's a company which dares to look at these tech giants eye to eye. Why is the New York Times suing AI firms? How is it different from other copyright lawsuits? And more importantly, what is at stake? Let's find out. The tale starts when, in response to a prompt, ChatGPT produces text that is near verbatim from a New York Times article. Looking at the similarity, one can easily get into the debate if this is plagiarism or not. But this debate is not simple. It gives rise to a trillion other questions like, does it amount to theft? If OpenAI and Microsoft rake in billions of dollars using creative reporting and journalism without offering fair compensation. Battle lines over generative AI's use of copyrighted work have been drawn again, this time by the New York Times. On December 28th, the news platform filed a lawsuit against OpenAI and Microsoft, creators of ChatGPT and other generative AI content, for unlawful use of its work. I think there's nothing transformative about using the Times content without payment to create products that substitute for the Times and steal audiences away from it. The complaint is the first AI copyright lawsuit within the news ecosystem, arguing that the generative AI models threaten the publication's business model and compromise the credibility of its massive investment in its journalism. Authors, visual artists, and composers have previously hit the two companies with copyright class action lawsuits alleging extensive theft. Let me tell you this. The lawsuit argues that the companies used millions of its articles to train chatbots as the likes of OpenAI's ChatGPT and Microsoft's Copilot that compete with the publication. However, in a sternly worded email, the New York Times emphasized the importance of settled copyright law to safeguard their journalism and content. I mean, if they have used their data for training a model, they must have compensated them. But the problem is that there had been no legislation at that time that ensured prevention of data from being used in AI model training. The statement conveyed that Microsoft and OpenAI are obligated to obtain permission before utilizing their work for commercial purposes, which, as a content creator myself, I believe is the correct approach. In this case, I think that the tech giants have in some way mistreated this requirement. While this is not the first case of this nature to challenge the way AI companies train their large language models, I still believe it has the potential to set an example for the relationship between copyright holders and AI companies. But that's not all. Coben's Wayfall Keegan, managing director of the International Association of Privacy Professionals in Washington, D.C., highlights the New York Times' historical role in pivotal free speech and copyright cases. Observing the unfolding lawsuit, he notes that the Times' involvement elevates the level of scrutiny on OpenAI for its use of materials in generative AI, adding a significant dimension to the unfolding legal saga. As this case unfolds, it's clear that the journey to resolution, whether through settlement or a court ruling, will be a protracted one. For enterprise leaders, it underscores the need for vigilant contemplation. The evolving legal landscape around AI demands thoughtful consideration, prompting crucial questions about the ethical and legal dimensions that should be at the forefront of our minds. The key takeaway here is, OpenAI is not the only AI company to face these kinds of legal challenges, but in many ways, its market-leading position has made it the face of this burgeoning industry. ChatGPT and OpenAI are almost always at the heart of AI debates over the technology's promises and its controversies. The lawsuits OpenAI faces could signal widespread changes for the AI industry as a whole. Back in April 2023, the New York Times initiated contact with Microsoft and OpenAI, engaging in discussions about intellectual property concerns. Prior to filing the lawsuit, the publication, as outlined in the filed complaint, discussed the prospect of a harmonious resolution. The exploration aimed at establishing commercial terms and technological safeguards, fostering a mutually advantageous exchange of value between the defendants and the Times. And if you ask me, it's clear that they just couldn't come to an agreement on the number. Before the Times entered the legal arena, numerous other copyright holders contested OpenAI's usage of their material for training ChatGPT. In September 2023, over a dozen prominent authors collectively filed a lawsuit against OpenAI for employing their books in the training process. Following suit a month later, non-fiction authors initiated a proposed proposed class action against OpenAI and Microsoft, echoing comparable complaints. As AI investment surges forward, additional lawsuits against OpenAI seem unavoidable, driven by the company's soaring valuation and substantial profit margins, suggests Joseph Thacker, principal AI engineer and security researcher at AppOmni. Regardless of the legal landscape, potential resolutions may materialize beyond the courtroom. An OpenAI spokeswoman, as reported by the New York Times, hinted at collaborative efforts with other publishers. In a noteworthy move in July 2023, the Associated Press disclosed a deal to license its news story archive to OpenAI. However, that's not all. As intellectual property disputes escalate, AI companies could increasingly adopt the strategy of procuring data before deploying it to avert legal conflicts, which, to be honest, is a super positive thing. Coben's Zweifel Keegan also advises that this preventative approach might become a core best practice, regardless of whether the legal framework evolves to address these concerns. But what will be the potential impact of this lawsuit? Many advocates of AI argue that challenges and potential regulation will hamper innovation, but lawsuits and new laws are likely to emerge. The New York Times case and similar lawsuits signal that copyright law may need to be updated to reflect the reality of a new technology poised to become as common as AI. Seko Campbell, a media and technology attorney and partner at the full-service law firm, emphasizes the absence of clear legal guidelines on treating the training of AI systems in relation to copyright law, whereas Campbell suggests that significant amendments to copyright law have historically followed advancements in technology, citing examples such as radio in 1909 and broadcast television in 1976. In my opinion, for now, AI companies and copyright holders have to make their arguments using existing statutes and court decisions. The legal policies of fair use and transformative use may emerge as pivotal barricades for AI companies facing copyright lawsuits, according to legal experts. Fair use permits the utilization of copyrighted material in specific circumstances, while transformative uses, defined by the U.S. Copyright Office, involve incorporating something new with a distinct purpose or character without serving as a substitute for the original work. Whereas I think the New York Times contends that the legal doctrines of fair use and transformative use do not apply in this case. As stated in the publication's complaint, the argument asserts that the outputs of defendants' Gen AI models compete and closely mimic the inputs used to train them. Copying Times works for that purpose is not fair use. There is a possibility that the New York Times case, or a similar one, could eventually reach the Supreme Court. Such a high-stakes legal showdown could play a crucial role in influencing lawmakers to revisit and revise copyright law. According to Seko Campbell, this particular case may provide Congress with valuable insights. A court opinion, he suggests, could guide lawmakers in addressing the litigated issues and reconciling them in a comprehensive statute. But this isn't it. If the New York Times wins in court, it may mean that AI businesses that wish to use news items from publishers will have to pursue licensing as their next course of action. Licensing deals are already being struck, like the one between AP and OpenAI. Apple is also actively pursuing deals with news publishers to use their material in the training of generative AI systems, according to the New York Times. On the other hand, Kristen Grant, the managing attorney at the intellectual property law firm, points out that even if a court were to rule in favor of OpenAI on specific fairgrounds use, such a decision might not universally apply to every use case. Further suggests that, depending on the nature of the uses made by AI company, there could still be a future requirement to secure licenses for certain types of uses. But how much will these licensing agreements cost? The New York Times is seeking billions of dollars in statutory and actual damage in its lawsuit against OpenAI and Microsoft. The information reported that OpenAI has made offers to license news articles from media companies ranging from $1 million to $5 million per year. That's just insane. I think they will start to see how expensive that is and what that looks like in terms of building out a playbook for acquiring legal rights to the use of copyrighted or other types of protected works for training generative AI systems, whereas licensing can also solve many copyright issues. AI companies with smaller models can easily reach out to copyright holders to license the specific data needed for training, but that issue becomes stickier for the larger foundational LLMs. And I must point out that you can't license the entire internet. In this growing landscape where licensing may become a legal necessity for AI companies during model training, lingering doubts persist. The New York Times lawsuit specifically demands the destruction of any GPT or LLM models and training sets that incorporate their works, as outlined in the complaint. The outcome of such demands raises questions about the fate of models found to be in violation of copyright laws. In the end, I think enterprises should prioritize ensuring the originality of their content by utilizing tools like plagiarism detectors. The key step for organizations is to validate the authenticity of their content before publication to mitigate the risk associated with copyright issues, and the rest can be easily sorted out. And to always stay safe, you need to be informed. For that, subscribe to Innovella, where I try all my might to bring the latest and greatest from the tech world.